The Factories Act, 1948, Act No. 63 of 1948, Chapter 9. Special Provisions. 85. Power to apply the Act to certain premises. 1. The state government may, by notification in the Official Gazette, declare that all or any of the provisions of this Act shall apply to any place wherein a manufacturing process is carried on with or without the aid of power or is so ordinarily carried on, notwithstanding that I. The number of persons employed therein is less than 10 if working with the aid of power and less than 20 if working without the aid of power, or E. The persons working therein are not employed by the owner thereof but are working with the permission of or under agreement with such owner, provided that the manufacturing process is not being carried on by the owner only with the aid of his family. 2. After a place is so declared, it shall be deemed to be a factory for the purposes of this Act, and the owner shall be deemed to be the occupier, and any person working therein, a worker. Explanation. For the purposes of this section, owner shall include a lessee or mortgage with possession of the premises. 86. Power to exempt public institutions. The state government may exempt, subject to such conditions as it may consider necessary, any workshop or workplace where a manufacturing process is carried on and which is attached to a public institution maintained for the purposes of education, to training, research or reformation, from all or any of the provisions of this Act, provided that no exemption shall be granted from the provisions relating to hours of work and holidays unless the persons having the control of the institution submit, for the approval of the state government, a scheme for the regulation of the hours of employment, intervals for meals and holidays of the persons employed in or attending the institution or who are inmates of the institution, and the state government is satisfied that the provisions of the scheme are not less favorable than the corresponding provisions of this Act. 87. Dangerous operations. Where the state government is of opinion that any one manufacturing process or operation carried on in a factory exposes any persons employed in it to a serious risk of bodily injury, poisoning or disease, it may make rules applicable to any factory or class or description of factories in which the manufacturing process or operation is carried on. A. Specifying the one manufacturing process or operation and declaring it to be dangerous. B. Prohibiting or restricting the employment of women, adolescents or children in the one manufacturing process or operation. C. Providing for the periodical medical examination of persons employed or seeking to be employed in the manufacturing process or operation, and prohibiting the employment or persons not certified as fit for such employment to and requiring the payment by the occupier of the factory of fees for such medical examination. D. Providing for the protection of all persons employed in the one manufacturing process or operation or in the vicinity of the places where it is carried on. E. Prohibiting, restricting or controlling the use of any specified materials or processes in connection with the one manufacturing process or operation. F. Requiring the provision of additional welfare amenities and sanitary facilities and the supply of protective equipment and clothing, and laying down the standards thereof, having regard to the dangerous nature of the manufacturing process or operation. 87a. Power to prohibit employment on account of serious hazard. 1. Where it appears to the inspector that conditions in a factory or part thereof are such that they may cause serious hazard by way of injury or death to the persons employed therein or to the general public in the vicinity, he may, by order in writing to the occupier of the factory, state the particulars in respect of which he considers the factory or part thereof to be the cause of such serious hazard and prohibit such occupier from employing any person in the factory or any part thereof other than the minimum number of persons necessary to attend to the minimum tasks till the hazard is removed. 2. Any order issued by the inspector under subsection 1 shall have effect for a period of 3 days until extended by the chief inspector by a subsequent order. 3. Any person aggrieved by an order of the inspector under subsection 1 and the chief inspector under subsection 2 shall have the right to appeal to the High Court. 4. Any person whose employment has been affected by an order issued under subsection 1 shall be entitled to wages and other benefits, and it shall be the duty of the occupier to provide alternative employment to him wherever possible and in the manner prescribed. 5. The provisions of subsection 4 shall be without prejudice to the rights of the parties under the Industrial Disputes Act, 1947, 14 of 1947. 88. Notice of certain accidents. 1. Where in any factory an accident occurs which causes death or which causes any bodily injury by reason of which the person injured is prevented from working for a period of 48 hours or more immediately following the accident, or which is of such nature as may be prescribed in this behalf, the manager of the factory shall send notice thereof to such authorities and in such form and within such time as may be prescribed. 2. Where a notice given under subsection 1 relates to an accident causing death, the authority to whom the notice is sent shall make an inquiry into the occurrence within 1 month of the receipt of the notice, or, if such authority is not the inspector, cause the inspector to make an inquiry within the said period. 3. The state government may make rules for regulating the procedure at inquiries under this section. 88a. Notice of certain dangerous occurrences. Where in a factory any dangerous occurrence of such nature as may be prescribed occurs, whether causing any bodily injury or disability or not, the manager of the factory shall send notice thereof to such authorities and in such form and within such time as may be prescribed.